Welcome to the Wills and Estate Transmission Podcast, brought to you by De Groots, specialist lawyers in wills and estates.
Hi, and welcome back to the Wills and Estates Transmission Podcast with De Groots. And today we're joined again with Julia Tutt. How are you, Julia?
I'm good, thanks, Tony.
Excellent. And today we've got a very intriguing topic that's going to be entertaining, shall we say. It's the forfeiture rule explained, losing your inheritance for taking a life.
Yes, I just thought, let's somehow, despite the topic, keep it a bit lighthearted and just shine a light on an interesting area of succession law that people don't, I don't know, hopefully they never have to come across, and it isn't a unique area of our practice that is often just happening behind closed doors per se, and it doesn't really come out in the public that much, despite how relevant it is and how crucial it is.
Well, relevance is actually correct, because most people might think, I'm not sure how relevant it is. People are unfortunately killing each other all the time.
They are. And on a darker note as well, couples are killing, there's a violence against women happening as well. And so kind of one of the main case, I guess, in the forfeiture rule was a matter where anyway, I'll get to that. But yes, between couples is often where it comes up.
Yeah, and of course in Hollywood and TV shows and whatever, the detectives rush over and it's always the partner that's suspected. And actually, in most cases, it actually is true. But then they look for the motive. And we've had a case recently, well-known case about a vegetable where a woman killed quite a few people in her family, and the motive is unclear. And she would definitely not gain anything financially from that.
Yes. So the forfeiture rule is basically, it's a common law public policy rule, which means that it's just been passed down through case law, and it is in the interest of public policy. Essentially, you can't benefit from someone's estate if you kill them, and you essentially forfeit your entitlement in their estate. So it's a very wide-reaching rule. So it applies to estates where you have a will. And so if I gift everything to Tony in my will, Tony kills me, he doesn't get anything in the will. And so it's important to look at the terms of the will of what happens if someone is not entitled. Are they considered to be predeceased? Does it go to the gift over? Who are the gift over beneficiaries, etc.? So it applies when there's a will. It applies when there's no will, and so someone might be entitled on intestacy. For example, a spouse might be entitled on intestacy, and the spouse kills the other spouse, and so they're not entitled. So that whole class of entitled beneficiary just disappears. It also applies to non-estate assets such as superannuation, life insurance policies, which is one that the movies and TV shows often latch onto, and jointly held property. So a lot of spouses, a lot of couples own property, their main residence, for example, as joint tenants. So they own it. Essentially, they both own 100% of the property. Upon one of their deaths, it automatically goes to the surviving person. And that process it's not a transfer of the property. It's not a transfer of 50-50. It's notifying the Land Titles Office that someone has died. That's what it really is. So it applies to that as well. The forfeiture rule applies everywhere. It is not forgiving. So, and it also applies, there was a case that tested this theory. It also applies in life interests. So there was a matter where a couple, one person, died, was not murdered, just died, and in their will they gifted a right of residence to their surviving spouse to live in this property that they lived in together. So essentially I think it was a woman, she gave her husband the right to live in this house for the rest of his life. And then at the time after his death, I think her son was entitled to the remainder of the house. So basically, once the life tenant died, then her son got the property. And what did the son do? Went and killed the life tenant. So he essentially accelerated his interest in that property. He thought, okay, well, this guy, he's taking ages to die. I just want that property. Killed him. I actually have no idea about the motives, but for the sake of explaining it, he killed that life tenant and accelerated his interest, and now he got the property early. And so in New South Wales, because this is a common law rule, in New South Wales there's a Forfeiture Act where you essentially apply, it provides a mechanism to have it amended or not apply, and that's where a lot of these cases come up. So that person or the family members said, okay, the forfeiture rule should apply because he's now received a benefit by killing someone. So therefore, the forfeiture rule should apply. It should still be relevant. And the court upheld it and said, yep, he killed someone. And they had to calculate when that person would have died if not for being murdered. So they were trying to calculate, got an actuary in, tried to figure out how old he would have been when he actually died, how old he might have been when he died, and therefore when that remainder beneficiary could have actually got the house. So they kind of just held it on trust until that time. It was all very complicated, but it applied. The court, if someone dies at the hands of another, whether it be manslaughter, negligent driving, no matter what the moral culpability is, it will apply. However, there are two exceptions. The first exception is if there is the murderer is essentially found not guilty or there's no conviction due to mental illness. So that's a whole separate process. I'm not a criminal lawyer, but there's no conviction at all, and it's due to mental illness. So that wouldn't apply. The other exception, which is very strange, and I think it must have come from a very faraway English case, is my guess. I don't think it came from Australia, but as I said, it's a common law public policy rule. It feeds through the cases. The other exception is if, for example, between Tony and I stabbed Tony, and then Tony had gifted everything in his will to me, right, previously, a year ago. I stab him, life-threatening injuries, fatal injuries, and in that moment between being stabbed by me and dying, you reaffirm your wishes to make sure that it comes to me. So you know that you are going to be killed at the hands of Julia Tutt, but you still want to gift it to her.
But I'm okay with it.
But you're okay with it. And so you reaffirm those wishes. That's the only exception. And it makes sense because you are aware of what's happening and you would say, no, I don't want that rule to apply, is essentially what you're saying in that moment. And I would assume it would be a moment because it has to be a fatal injury. It has to actually eventually kill you. So that's the only time that the forfeiture rule won't apply, essentially, as the case law stands now.
Okay, I just thought of something, and I always think of something pops up weird in my head. So if I go to kill somebody and I'm unsuccessful in killing them, but they end up in a coma, they're in a coma, they're unable to do anything, right? And I'm there as the person assigned to look after them and take care of their estate. Can I still benefit although they're not dead?
Well, that's different because they're not dead. So then you look at the power of attorney and the appointment of enduring documents, appointment of enduring guardian documents. That's what would be in effect. If they're not dead, the will isn't relevant.
Right. So what happens when they do die and they say, well, they died because of what you did years ago?
I think that would be a matter for the criminal case as well, like whether they did lay criminal charges because that person did subsequently die and the cause of death was the murderer's actions. That would be probably one, if there was some question about The cause of death, there might be some argument, and that might be where the Forfeiture Act comes in, and that the family would step in and make an application.
Yeah, because of course, even under manslaughter, there was a case about manslaughter, and still, manslaughter isn't murder, but it still applies.
Yeah, so manslaughter is, again, I'm not a criminal lawyer, but manslaughter lacks the intent. It lacks the mens rea, the intent to kill, the premeditation to kill. So in this matter of Troja and Troja, it was a couple, and a woman was found guilty of manslaughter against her husband. She killed her husband, but it was maybe she was originally charged with murder, and she was found guilty of manslaughter though. And so because she killed her husband, the forfeiture rule applied. So in his will, he gifted everything to her. If she didn't survive, then to their kids, and then if they didn't have kids, then to his mother. So the killer's mother-in-law was going to be entitled. So as it turned out, they didn't have children. So if the forfeiture rule applied, meaning the killer didn't receive anything in her husband's will, everything went to her mother-in-law. So she made a couple of arguments. She asked for this forfeiture rule not to apply. It ended up in the New South Wales Court of Appeal. Essentially, her main points as to why it shouldn't apply were that she had no motive to kill. She didn't have the motive to kill and therefore benefit from his estate, which is an interesting point, just thinking off the top of my head, because yes, there's manslaughter, but a lot of people kill others not with a motive to benefit from the estate. That's not often a motivator to kill, but she was kind of making that point that there was no motive on her part to kill. That's the manslaughter aspect, and also not benefit from his estate. Her second point was that she had contributed to that wealth that was accrued by this person that she killed. And so that was now going to her mother-in-law. And therefore that mother-in-law would now be unjustly enriched from the estate. And she got nothing. So, and I do think, I don't know the judgment on the criminal side, but I think that there was some domestic violence involved. And so maybe that had a play in why she was lying and why she maybe was charged with manslaughter in the end. But the court decided that the forfeiture rule would still apply, and her moral culpability was not relevant. And there was a lot of discussion. This was a matter where there was a lot of discussion about moral culpability and whether whether the courts should be looking at this forfeiture rule and deciding when it would apply due to, the moral culpability of the killer. The Court of Appeal said, no, it's just going to apply. If you kill someone, you don't benefit from their estate. So there's all sorts of tests, and people are going to it's going to keep on coming through the courts. It's not as common as you'd think. I think a lot of the time it just is dealt with between the families and between the lawyers, but it doesn't always become a published judgment before the court. But it is there. That rule is there, and movies and TV shows have been taking extreme liberties in relation.
Absolutely, yeah.
Mm-hmm.
Well, getting back to that one you were talking about in common law, I'm thinking maybe back in the day when the king could kill whoever they wanted, and the rule wouldn't apply to them because they're entitled to kill who they want, how they want, and then they're on the rack and they're about to die, and on the rack, about to die, yes, give me all your estate, I'll look after your family. Okay, there you go. I don't know.
But that would only be if the king was entitled.
The king's always entitled.
Yeah, I guess it depends on what period of time we're talking about.
Exactly.
But yeah, it's about if I'm entitled under your will and I kill you specifically, that's where we're talking.
Yeah, exactly. Yeah. And look, guys, we're coming up to the end of the year, another great, busy, successful year, and we thought we'd do a nice, light podcast to finish the year. So we're not taking light liberties of the issue, but you know what? It's a quirk. it's nice to have some quirks in the law. Law isn't known as being humorous, so why not?
Yes, as I said in the last podcast, it can be funny quite quickly.
Yes, exactly right. We had that, and the family getting together talking about the estate. Well, who gets what and whatever before you die. That was to do with the what was that one again?
That was mitigating risk of financial elder abuse.
That's right. Yes, and
Yes,
especially
and
with
having open
Alzheimer's.
conversations. But hopefully you don't
Yes.
need to have open conversations about this. I think the main takeaway is
No.
don't kill your family members.
Well, literally, that's true.
Hmm.
There's no benefit for killing
No,
your family
there's no benefit.
ever. Full stop.
Exactly.
Don't do it. All right, great. Thank you very much, Julia. That's been great fun.
Thanks, Tony.
Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website www.degroots.com.au and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.